Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. I would like to introduce myself. My name is Erna, and also I would like to introduce my colleague, Siti. We would like to present a paper in University of Muhammadiyah, Gresik, a conference on health, social science, and humanity 2020. The title of our paper is The Limitation of the Right to Assembly and the Right to Movement in order to fulfill the right to health of society in the COVID-19 pandemic in Indonesia. At the background of this paper is coronavirus has been announced by World Health Organization as a worldwide pandemic. Data on global distribution of countries infected of coronavirus based on WHO on 4 December 2020. There are 64, 350,000 and 473 confirmed cases, and also data from Task Force for the Acceleration of Handling COVID-19 is 563,680. WHO recommended to Indonesia to improve the emergency response mechanism to immediately establish national emergency uh, status. In order to avoid further spread of the virus in various countries have policy differently in the implementation of public health emergency, including Indonesia. Emergency status are stated in Article 12 of Indonesia Constitution. It said that President has the right to declare the state of emergency. In Article 22 of Indonesia Constitution, President also has the right to issue government regulation in lieu of law if the state in crisis situation. Indonesia has enacted regulation that lead to the protection of fulfillment public health for the public interest. On the other hand, there are restrictions for other rights such as the right to movement and the right to assembly. So the study will examine the right to health, the right to assembly, the right to movement in the Constitution. It will analyze whether the limitation of these rights are justified in the Constitution and also in the international principle of law. This study, we will use the methodology in normative legal research and also a statutory and a conceptual approach. We will discuss this paper according to the right to health, the right to assembly, and the right to movement in the Constitution and regulation in Indonesia. WHO states country must act in accordance with Article 3 of the International Health Regulation 2005, which take into account respect for dignity, human rights, and fundamental freedom of person. There are at least 3 human rights in Indonesia affected by the COVID-19 pandemic in this paper, namely freedom of assembly, freedom of movement, and also the right of the health. The regulation to combat COVID-19 in Indonesia, firstly, is Law Number 4 of 2007 on disaster management. It is said that non-natural disaster are disaster caused by event or a series of non-natural events which include technology failure, modernization, epidemic, and disease outbreaks. The government can design disaster-prone areas to be prohibited areas for settlement or revoke or reduce part of all the ownership right of each to an object in accordance with statutory regulation. Secondly, Law Number 6, 2008 on health quarantine. Public health emergency as extraordinary public health event marked by the spread of infectious diseases or even caused by nuclear radiation, biological pollution, chemical contamination, bioterrorism, and food that cause health hazard and potentially spread across regions or across countries. This law provides several alternative countermeasures for the emergency of a public health emergency situation, which is conducted through host quarantine, regional quarantine hospital, and quarantine of rights prohibition of pembatasan skala besar. The thirdly is Law Number 2 of 2020 on stipulation of Perpu Number 1 of 2020. This is the ratio legis of this enacted law is due to the spread of COVID-19 pandemic that had an impact and threatened Indonesia economic growth, among others due to the decline in state revenue and global economic uncertainty requiring extraordinary policy and step in the part of state finance, regional financial and financial sector that must be taken immediately by the government and related institutions in order to overcome this urgent condition in the context of saving health, social safety net, and the affected business force. So this is the regulation according to the protection of economic in Indonesia. So to implement those laws, government enacted government regulation number 21 of 2020 concerning the guidelines of large-scale social registration is the limitation of certain activities of residents in areas suspected of being infected with COVID-19 to prevent its spread. So there is divided into zone in Indonesia. For example, Jakarta is a red zone. Regional government can carry out PSBB or restriction the movement of people and goods in one particular province or district based on approval of the Minister of Health. The government action to issue a Perpu has sparked a little debate whether the COVID-19 emergency in Indonesia is the same as the state emergency in Article 12 of the Constitution. However, Perpu number 1 of 2020 letter, which is approved by the House of Representatives to law, do not mention Article 12 of the Indonesia Constitution. It refers to Article 5, Article 20, and Article 22, which state is compelling crisis situation. President have the right to issue government regulation in lieu of law. According to Ghibli Asidiki, the expert of human rights and state law in Indonesia, the situation has continued as de facto emergency, but not recognized as the jure state emergency. So the implementation of Article 12 Constitution is not properly due to historical trauma to implement law number 23 of 1959 concerning state of emergency, which is constructed in atmosphere of war and armed conflict. That's why the government only refer to Article 5, Article 20, and Article 22 of the Constitution. It can be seen that government implement various laws to handling of COVID-19 in its economic impact. The second we will discuss is the limitation of the right to assembly and the right to movement that can impose restriction on human rights in Article 29 of Universal Declaration of Human Rights and also International Covenant on Civil and Political Rights. In exercising his freedom, everyone is only subject to the restriction determined by law solely to guarantee recognition and respect for the right and freedom of others to fulfill the requirement of morality, public order, and just public welfare in a democratic society. Another principle in the international law is the concept of a state emergency has detailed requirement in the International Law Association Paris Minimum Standard on human rights norm in a state of emergency. The declaration of state of emergency should be for a fixed period defined by the Constitution, and that extension should be subject to a prior legislative approval. Indonesia already has an article on state of emergency in this constitution, but law number 23 of 1959 is a repressive law and often abused by the authority to silence democracy. There is another principle is in Syracuse principle. It is said that public health can be invoked as a basis for limiting certain rights, so that the state takes steps related to the existence of serious threat to health of resident or individual members of the community. For this, we have the three conditions to restrict other human rights. One is serious threat to health of resident and to prevent illness, and also use international health regulation for WHO. The restriction on human rights in Indonesia must be implemented based on law, taking into account moral values, religion values, security and public order in a democratic society. It is stated in Article 28G Indonesia Constitution. The restriction of the right to assembly and the right to movement to prevent the spread of COVID-19 is regulated by law based on the crisis situation, but do not considering human rights perspective. I will conclude my presentation that the right to assembly, the right to movement, and the right to health are guaranteed in Indonesia Constitution. In preventing the further spread of COVID-19, the government has enacted numerous laws and also stipulated emergency conditions. There are no laws which refer to Article 12 Constitution, state of emergency to combat COVID-19. The limitation of freedom of assembly and freedom of movement can be justified in Indonesia Constitution, but there is no specific consideration on public health. It is different with in the ICCPR and Syracuse principle. I would like to recommend this paper to make law reform or use constituendum to amendment of law number 23 of 1949 regarding state of emergency, which regulate the criteria of state of emergency, the period of state of emergency, the limitation of human rights, and the protection of vulnerable people. This is at the end of my presentation. Thank you for your kind attention.